Want to thank you all again for attending, um, and want to just describe the last topic because I'll be presenting it. We could do a week on this. We really could, because uh, there are just a lot of things I think each of us know that probably not all of us know that would be very useful in defending abuse and neglect cases. We don't have a week, we got a day. And so, what this last topic, what I wanted to do was basically take every little idea that I've ever had in a DSS defense case that I've used or that I've seen used that's seemed good and put it in one half-hour topic. Now, you're not going to get all of it in a half an hour. I wouldn't get all of it in a half an hour. But what reason you've got a disc as opposed as in addition to your handwritten materials is bound materials is when I came up with this topic. I wanted to make it so you could cut and paste. So steal from this, okay? These topics, I'm going to go into each for like 2 minutes, but there's some writing on each of them, sometimes citing case law or statute. Feel free to cut and paste. That's what it's there for. When each of these topics is going to suggest a motion or something that you can do in a DSS case, just feel free to cut and paste. And I think you'll find these topics, not going to try to give them at least a brief overview of what you can do that very rarely gets done. Okay. First hot tip. Attorneys for a person who's named in a report or investigation pursuant to abuse and neglect statute. So even before a case gets filed, if you're representing somebody in the investigative stage, there's not even a case filed, you're still entitled to a copy of most of the DSS file. They're going to redact they're going to redact the reporter. They're probably going to redact certain medical information, but they will keep enough so you can go get the medical information. But you're entitled to the file. You don't need an order of discovery. South Carolina code section specifically authorizes you to get a copy of that file. And I just send a standard letter to DSS, and that's all it says. It's one sentence, but I guarantee you, if you retain me in a DSS case, you will not leave my office before that letter gets faxed to a DSS attorney. That is the first thing I do after getting a retainer agreement and getting a check or money order or cash. That is the second thing I do, is I send that letter to DSS, okay? Because we've got very compressed time frames, and I want that file. I want that file yesterday. So if you aren't sending that letter to DSS pronto, first thing, first day you get retained, there's just no excuse. You've now been told, letter's in that disk, copy it, paste it to your word processor, you got that letter. Okay, next hot tip. In any hearing that requires the court to make factual findings, you can probably require testimony. Now, there is a case, came out last year, one of my local judges did a permanency planning hearing without testimony. She got, actually I don't think she got reversed because it was harmless error, but they said testimony. If you're going to make factual findings, testimony. I would request testimony at hearings. We've had a lot of discussion. Obviously, permanency planning hearings, it's very clear you're entitled to testimony. That's what Ex parte Morris says. But there are other hearings that clearly require factual findings. And I think under the holding of Ex parte Morris, I have 99% certainty that if you handed up Ex parte Morris, a copy of the statute showing that this requires the court to make factual findings, that you would get testimony hearings in any child hearsay proceeding. And one thing Jay didn't really deal with much in his presentation on the 19-1-180 hearsay exception is the fact that it requires substantial factual findings from the court. And am I litigating those cases? I've actually never had to have a hearing on a 19-1-180 yet, but I've prepared for those hearings, and it's been my expectation in preparing for these cases that I may spend more time on that hearing than I will on the merits hearing. Because if I can keep all the hearsay out, and DSS has a choice of putting a kid on the stand or dismissing the case, they may dismiss the case. Or they may put the child on the stand. The child will testify for 15 minutes or an hour. But you're not going to have 15 experts up there taking a 3-minute or 5-minute interview they have with the child, or 15-minute interview with the child, and turn it into a 2-day cross-examination, direct examination on the child's reliability. So, child hearsay hearings, I think under Ex parte Mors, you are entitled to testimony. Permanency placement plan hearings. No one's really discussed this, but you are almost certainly entitled to a hearing on a placement plan. Now, again, I've never had a hearing on a placement plan. I'll tell you why I've never had a hearing on a placement plan. Every single time DSS or the guardian wants to put something in the placement plan, I ask them the following question. How does this remedy the conditions that led to the child's removal? And if they can't answer me and they still want it in the placement plan, I say, fine, let's set the matter for trial. And every single time they back down. Now, eventually they're not going to back down, I think. Maybe I'll get lucky in my career. But until they back down, I'm demanding hearings in that placement plan. Next hot tip. Expert testimony on a child's credibility is inadmissible. Case that I'm citing is State versus Dempsey. But this case, this language is cited repeatedly, and actually it's cited in State versus Dempsey with emphasis, with italics. We have said it before, and we will say it again, this time with emphasis. No psychotherapist may render an opinion on whether a witness is credible in any trial in this state. The assessment of credibility is for the trier of fact and not for the psychotherapist. Now, I will tell you the psychotherapist in this case was Dr. Don Elsey at my local Low Country Children's Center in Charleston. That's where children in my area go evaluated for sexual abuse. I will tell you that in 2006, Dr. Elsey testified and gave an opinion on the child's credibility in a case where I was the attorney for the child, so I didn't object. And he was listed as an expert witness on a case where I represented the parents and never went to trial, but I guarantee you they were going to try to get him to testify as to the child's credibility in that case. It still happens. It's the same dang person, same time therapist. But if you don't object, DSS is going to, if I knew that I could get it in, I was a DSS attorney, why not bolster my case? But if you're letting it in, that's malpractice. Okay, next tip. Impeach DSS experts through the use of treatises. That book that JLA was talking about, Jeopardy in the Courtroom, by C.C. and I forget the other author's name, those folks are considered experts by most of the people at Low Country Children's Center. Well, you know something great? In cross-examination, if you can get somebody to acknowledge that these folks are experts or this is expert stuff, you can use that to impeach them. So I can use Jeopardy in the Courtroom anytime I want to impeach the Low Country Children's Center's experts. It's great. Find out when I take the deposition of the expert or in discovery, I send out Rule 803.18 talks about what can be used. And in cross-examination of the state's experts, you can put the treatise in. You can have it read into evidence. It's direct evidence. So it acts as, it's like you don't have to hire the expert. You can just use the book. So in my request for production, I asked for copies of the CV of any expert witness the DSS tends to call, copies of any learned treatise that they will rely upon, and copies of any reports that they've reviewed in coming up with their opinions that I haven't already requested. And then if I get to depose the expert, I ask him, what do you consider to be the experts in this field? What materials do you consider to be the experts in this field? And then I go read those things. And if it contradicts what they said, I can jam it down their throat at trial. So don't let DSS's experts just get up there and say whatever they're going to say. Find out who they rely on, and then use the experts that they rely on to impeach them. Next hot topic. The burden of proof for a finding of abuse and neglect may be unconstitutionally low. Now, this is much, this topic would take me a few hours to go into in great detail. But you actually have my brief in your materials. And what I mean by that is I got retained a few years ago, wasn't the trial attorney, to litigate this very issue because it was an issue I'd already memoed on another case. Took it to the Supreme Court. And I will tell you that if you take it to the Supreme Court, you will have Justice Tola convinced because she's wondering how it's in the best interest of the child to raise the burden of proof. And I'm still working on my answer the next time she asks it. But it wasn't preserved well enough, so it was an unpublished opinion that didn't get to this issue. I figured if they really didn't just want to say, nah, it's constitutional, they could have just said it's constitutional. They decided not to get to that issue. So it gives me some hope. And I will tell you, you've got a brief in there. And the only thing I ask, you can use all my materials without attribution, but if you take this to the Supreme Court, I want my name on the brief. That's all I'm asking. The reason I say it may be unconstitutionally low is the standard is preponderance of the evidence. And the first statute I cited is for removal actions. The second I've cited is for intervention actions. But due process, I'm relying on a couple of Supreme Court opinions to make this argument. Due process is flexible, and it calls for such procedural protections as the particular situation demands. And there's this Santosky versus Craner case, which is a termination of rights case, but it says that clear and convincing evidence is mandated when an individual's interest is at stake in the proceedings are both particularly important and more substantial than mere loss of money. It strikes me that losing your kid in a removal action and being branded a child abuser is particularly important and more substantial than the mere loss of money. And I'm not going to go into great detail, but all the analogy I see indicates to me that a clear and convincing evidence standard is quite possibly required for a finding of child abuse. There are, in my materials, I cite a number of state statutes, a number of state Supreme Court opinions saying preponderance of the evidence is not correct standard, clear and convincing is the correct standard. So I think there's a great argument that our burden of proof is unconstitutionally low. And I would urge you, in every case where you're going to a merits hearing, at least take my materials, throw it into a memo of law, make the argument, because one of these days you're going to have a close case. And the ability to raise the burden of proof on DSS may be the difference between winning and losing that case. Next thing that might be unconstitutional, another thing I've actually briefed to the Supreme Court and was not preserved well enough, same case, the child hearsay exception under the South Carolina Code may violate the Sixth Amendment, also the 14th Amendment. I think you've heard Jay Elliott talk about those two cases. And he has also spoke about this, the statements made as part of this are typically considered testimonial, and talked about the case of South Carolina Department of Social Services versus Wilson, which notes, because one of the issues obviously in the Crawford case is, well, that applies to criminal, but what about civil? But South Carolina Department of Social Services versus Wilson says the confrontation clause is explicitly implicated in abuse and neglect proceedings. So I think the syllogism is real simple. Confrontation clause is implicated in abuse and neglect proceedings. The these statements to the medical evaluators are testimonial in nature, and therefore they're inadmissible unless the child testifies. Okay. In some circumstances, it's possible to request and obtain an independent medical examination of the alleged child victim. A lot of times, the child gets to the forensic examiner under very suspicious circumstances. Mom and dad are in a contested custody case. Mom takes the child into Low Country Children's Center, says, Dad's been doing this and doing that and doing the other thing. And so the caseworker goes into the interview. Some of them are really good about it, some not so good, but they go in with this set assumption that child's been abused by dad, and the interview starts from that assumption. And sure enough, they tend to come to the conclusion the child's been abused by dad. But there were flaws in the interview. There were flaws in the interview process. There are facts in the report that just simply aren't correct, or there are questions that should have gotten asked that aren't asked, or coaching isn't really an issue that's addressed. Go and move for an independent medical examination. Okay? Now, I'll tell you, this can be a double-edged sword. One of the times I was successful, we got an independent medical examination, and that examiner said, yep, looks like your client abused this child. And that made it a much harder case. I probably, in hindsight, would have been better just taking a very flawed medical exam and fighting DSS on that. But on the other hand, because even DSS acknowledged that this second medical exam had come back, and for a while she was wavering as to whether she thought my client had done it or not. If she'd come back and said my client didn't think my client had done it, they would have dismissed that case. So that would have been an easy victory. Next hot tip. Nothing in the abuse neglect code prohibits the deposition of the alleged child victim. I depose children. I'm not necessarily thrilled to do it, but frankly, if my client says the child's lying and the case is going to be a credibility battle between my client and the child, I want to depose the child. And the reason I want to depose the child isn't to traumatize the child. It's because these medical examinations, they're generally very brief. They don't ask a lot of the important questions. The DSS caseworkers rarely ask a lot of the important questions. And then what you end up with is you hear the child's statement for the first time fully at trial, and now it's too late to find out how to impeach that child because you don't know what inconsistent statements the child may have made to other people. You don't know, the child might say something that there would be some evidence of what the child's saying. Maybe the child said, I went to this baseball game with my dad on, this date, and that's when he abused me, and you find out that your client was actually in Timbuktu on business that day. Well, if you don't hear that until trial, it's too late to develop the impeachment. So there have been times where I've even agreed that unless the judge wants additional testimony, this deposition will be in lieu of trial testimony, it will be videotaped. But I want to question the child under oath before trial if credibility is going to be an issue. Okay? I mean, that is just automatic. If it's a credibility contest, I'm going to do everything in my power to get that deposition before trial. And I think that eventually, if I ever had to appeal it, because I've always been granted the deposition, but if I ever had to appeal it, I think I'd probably have an appealable issue because it really does limit your ability to defend your client. Before filing a motion to take the child's deposition, I take the counselor's deposition. The reason I do that is one of the issues that's going to come up in wanting to take the child's deposition is how traumatized the child will be by testifying. And so you want to ask in the deposition of the counselor, what is going to be the likely trauma of this child if she has to testify or he has to testify? How can we minimize that trauma? And then when you take that, you do your motion to take the child's deposition, you can show that the child's own counselor says that testimony will be okay or minimally traumatic under these conditions, and maybe you'll agree to those conditions. And as I said, I've never not had the court allow it when I've brought these motions. So again, use the counselor's deposition to show the court the child can be deposed without suffering severe emotional trauma, and bringing the motion, prepare to show what information needs to be established from the child's testimony that cannot be established from the child's previous recorded statements. Okay. Next tip, probable cause hearing can be a very useful discovery tool. Okay, don't just use it to try to defeat probable cause or get the child returned, because a lot of times you're going to know, probable cause is a pretty low standard. And I've had maybe 2 or 3 cases in my career where I've defeated a probable cause finding in a DSS case. Most of the time they're going to find probable cause, but it's a very useful discovery tool. Probable cause hearing, you are allowed to cross-examine the witnesses as to whether there exists a probable cause to effect emergency removal. Typically, they'll present its caseworker as its witness, and using the cross-examination of the DSS witness, learn about the case, discover where the child's been evaluated, determine what witnesses might exist regarding the allegations, and you can also develop claims of inadequate investigation or hasty conclusions by DSS in removal of the child. I can always tell when I've done a good job at the probable cause hearing. It's very simple. If that caseworker doesn't testify at trial, I've done a good job at the probable cause hearing. And that happens a lot, but you can, if you show up, show that they didn't know what they were doing when they removed the child, I guarantee you there will be a new caseworker for that child within a week, and that caseworker at the probable cause hearing will never be called a witness at the merits hearing. Even if probable cause existed at the time of removal, there are circumstances in which the case can be dismissed at the probable cause hearing. And what I mean by that is probable cause involves a two-step finding. Involves, was there probable cause initially to remove the child, and was there probable cause, is there still probable cause to believe that the child will be harmed if returned to the parent? And there can be circumstances, and I think of a perfect case I've had where I wish I'd been the attorney at the probable cause hearing. Mom and dad leave the child home, well, dad leaves the child home alone at 2 a.m. to go pick up mom from work. Comes back to find child on the front lawn with the apartment manager and the police there. And mom and dad get into it, well, mom gets into an altercation with the police, ends up getting tasered. Child goes into EPC. Well, what lesson did my clients need to learn from this? Don't leave the child home alone at 2 a.m. when mom needs to get off work. Just mom needed to get taxis home from work is what mom needed to do. I think my clients learned that lesson. I don't think they needed the child removed for more than 3 days to have learned that lesson. And if DSS wanted to turn this into an intervention case and monitor the situation, that would have been fine, I think, by me at the probable cause hearing. But nobody advocated return of the child at the probable cause hearing. There was clearly probable cause to remove the child, although maybe, certainly if the child had been removed before the parents returned, there would have been probable cause. But is there really a need to keep this child from his parents when the parents have clearly gotten a lesson? We can't leave this kid alone. He's capable of getting out of the crib, getting out of the house, and wandering out in the street if we leave him alone, even at 2 a.m. I think that's a lesson learned, but no one made that argument. And so that child ended up out of their house for 6 months until they hired me, and then he got returned. Okay, so the probable cause here, as I said, not only determines whether probable cause exists at the time the child was taken into emergency custody, it's also whether probable cause remains to retain legal custody at the time of the hearing. Okay, next tip. Probable cause is found. There are circumstances in which the child can be returned home pending the merits hearing. There won't be a lot of them, but that earlier example I gave you this morning of where we were able to get a family friend into the house for the couple, the parents who were smoking marijuana with the newborn, get the family friend into the house, child can be returned home. The best thing you can do for a child, especially a very young child, is put that child back in the home so that stability and bonding can occur. So one of the functions of the probable cause hearing is determine whether continuation of the child in the home would be contrary to the welfare of the child. If you can figure out a way to make that child safe in the home pending the merits, come to the court with that plan. Use affidavits, which you're allowed to do. Use cross-examination of the caseworker. I'd actually ask the caseworker, why wouldn't this work? Why wouldn't this work? Why wouldn't this work? Make them justify why your plan to get the child back in the home won't work. And the code, DSS will often say, we can't return the child home if the child's been removed pending a merits hearing. The code specifically anticipates that it can be done, because it says if the child's returned home pending the merits hearing, court may impose such terms and conditions as it terms appropriate to protect the child from harm, including measures to protect the child as a witness. So the code actually anticipates that the child can be returned home despite a finding of probable cause, because if there's no probable cause, there won't be a merits hearing. So it anticipates the child can be returned home. That marijuana case I was telling you about, that's the only case I've ever heard about where the child was returned home despite a finding of probable cause pending the merits hearing. Now, I've got to imagine there are a lot of opportunities to return these children home pending the merits hearing, and it just takes creative lawyering and understand that you can do it to go do it. Next tip. Even if probable cause is found, there are circumstances the parent's visitation can be unsupervised pending the merits hearing. DSS will always tell you, it's got to be supervised, it's got to be supervised, it's got to be supervised. It's not in the statute, and it does not have to be supervised. Now, obviously, if it's physical or sexual abuse, it's going to be supervised. But if it's simply the parents didn't have an adequate home for the child, let them take the child to the park for 3 hours, 2 times a week. Anything that gets it unsupervised and not having to be monitored by a DSS caseworker, because then, as Sherry points out, you're going to get 26 hours of visitation a year. hour every 2 weeks. So if you can get the visitation unsupervised, that's great. And don't accept DSS as it's got to be supervised. There's nothing in the statute that requires the visitation be supervised. Okay. Another tip I spoke about earlier, return the child pending the merits hearing is not sought. Try to locate an acceptable custodian prior to the probable cause hearing. The sooner you get that child out of foster care and into a home that your client is comfortable with, the better off everyone's going to be. The Abuse and Neglect Code makes specific provisions for expedited placement of the child with a relative of the first or second degree. A parent whose child is in foster care is going to be a very anxious parent, as I pointed out. Parent is more likely to trust a friend or family placement as compared to an unknown foster parent. And friends and family, parents are often more willing to supervise visitation as compared to a foster parent. Finally, the child's less traumatized if placed with someone he or she knows. Next little tip. We haven't talked much about the interstate compact on the placement of children. But sometimes the best placement you're going to get, especially if it's likely that your parent is going to be dysfunctional for a long time, is an out-of-state relative placement. And that implicates something called the Interstate Compact on the Placement of Children. It's the ICPC. Now, I tend to be dealing more with ICPC issues when someone retains me, a relative will retain me as a third-party intervener. That is, mom and dad are really dysfunctional, child's been in foster care, and grandma or aunt says, well, heck, they're never going to get their act together. I want to get this child. I don't like having my niece or grandson or granddaughter in foster care. So they hire me, and I want to get that kid out of foster care and into Ohio or Tennessee or wherever. And DSS will say, we need a home study. Well, that's going to take months because you're not dealing with just one DSS bureaucracy now. You're dealing with two DSS bureaucracies. You're dealing with the DSS bureaucracy in South Carolina and the DSS bureaucracy in whatever state you want to ship the child to. And the state you want to ship the child to is going to probably have to arrange and pay for the home study. And it's like, well, heck, this child isn't our problem now. So why should we make it our problem? So it's just going to take forever. Judges can order expedited home studies sometimes, but what authority does a family court judge in South Carolina have to order Ohio or Tennessee or to do an expedited home study? None. So you want to try to avoid the home study. The ICPC, which is Code Section 20-7-19, nothing in it requires a home study. It has certain requirements, and subsection 3 sets the conditions that have to be met before an out-of-state placement, and the only condition that the receiving state must meet, that is the state that's going to get the child, is that it notifies the sending agency in writing of the fact that the proposed placement does not appear to be contrary to the interests of the child. So if you want to ship the child to grandma in Tennessee, find out what Tennessee needs, because it isn't what South Carolina DSS is going to tell you it needs. It's what Tennessee needs that you're going to need to find out to get that child. If Tennessee doesn't need a home study, you don't need a home study. The receiving state, again, it's comfortable with that provision. Without a home study, there's no need for a home study. Okay. Placement plans can be amended for good cause shown. Purpose of the placement plan is to provide a guide as to what the parent needs to do to remedy the conditions that led to the child's removal. And a lot of times, the placement plan, which initially looks like it's going to do that, doesn't do that. Sometimes the parent's going to be unable to complete that placement plan for having nothing to do with the parent's willingness to remedy the conditions. I've had situations where they want a parent to get particular services, and those services are no longer being offered by that agency, or the services are redundant. In those circumstances, you might need to move the court to amend the treatment plan. And so what you've got to do is file a motion to amend the placement plan. And that's it. Use those tips, and hopefully those tips will be useful to you in your cases. Any questions? Shuri?